got three really interesting panelists and I think a lot of interesting stuff to discuss, so we'll dive right in and get started. So I'm Michael Scott-Cole, I'm a member of the Volume 11 Executive Board of the Stanford Journal of Civil Rights and Civil Liberties, which is extremely excited to welcome all of our guests who I'll introduce in a moment and to put this panel together. A lot of hard work went into this, both from Editor-in-Chief Jack Kiter, Executive Editor Alex Twynham, and many others on the board. So we're all really appreciative to everyone who's turning out on this Saturday morning. We have three really great panelists with a range of different expertise that it would take too long to list all of it. So you've got your programs, you can read all about their many impressive qualifications, but I'll just briefly introduce each of them, and then I've asked each to prepare some opening remarks, and then we'll have some discussion among the panel, and we'll try to leave at least 20 minutes at the end for questions from the audience as well. So first, to my left, John Dernbach is a distinguished professor of law at Widener University, where he is co-director of the Environmental Law Center there. He's a leading scholar of environmental law and is particularly well known as an expert on Article 1, Section 27 of Pennsylvania's Constitution, added in 1971, which gives the people a right to clean air, pure water, and the preservation of the environment, and makes the state itself trustee over its natural resources, which it has a duty to conserve. To his left, Ilona Turner is legal director of the Transgender Law Center, the leading national organization dedicated to advancing the rights of transgender and gender nonconforming people. Her work involves both affirmative litigation under the California state constitution to vindicate privacy rights of transgender individuals, as well as defending legislation designed to protect LGBTQ students against constitutional assault. And she also previously, while at the National Center for Lesbian Rights, was involved in state court challenges to Proposition 8. So she had the, as we were just saying before the panel, she had the interesting responsibility of trying to make state constitutional arguments for why a state constitutional amendment was unconstitutional. And then finally, we have David Sapp, who is Director of Education Advocacy for the ACLU of Southern California, where he's been an advocate for underserved public school students throughout California, both in the courtroom and outside of it, with focus on juvenile justice issues and education finance reform. He is also my former boss from my summer internship, and as such will be receiving only softball questions. So without further ado, let's get into this. Professor Dernbach, if you'd like to start off, and we can just move down one.
Good morning, everybody. Good to see you here. I remember when I was in law school, how important conferences were like this were to me, because they reminded me that there was another side of the mountain. And got to the other side of the mountain, there was some pretty cool stuff that made it all worthwhile. And so it's especially on a Saturday morning, that's good to see you. My story starts, in a way, back in April of 1969. When a young lawyer and legislator from Sunbury, which is up in the anthracite country in Pennsylvania, took the floor in the Pennsylvania House of Representatives. And he said, and I'm going to read you a little part of this because I wanted to get it right. Mr. Speaker, he said, I rise to introduce a Natural Resources Conservation Amendment to Pennsylvania's Bill of Rights. I believe that protection, I do so because I believe that protection of the air we breathe, the water we drink, the aesthetic qualities of our environment has now become as vital to the good life, indeed to life itself, as the protection of those fundamental political rights, freedom of speech, freedom of press, freedom of religion, of peaceable assembly, and privacy. The amendment drafted was changed twice in the legislature because the legislature felt like the text mattered and they wanted to get it right. Under Pennsylvania procedure for constitutional amendments, it was passed by 2 consecutive sessions in the legislature, and then it was passed by a 4-to-1 vote. in May of 1971. The amendment says something like this. I mean, Michael actually got quite good, and so I'm going to be doing, if you will, pedagogical repetition. The first sentence of the amendment creates a right in the people to clean air, pure water, and to the preservation of the natural, scenic, historic, and aesthetic values of the environment. And the second and third sentences create a right, again, in the people to the conservation and maintenance of public natural resources. They're beneficiaries of a trust. The state is obliged to conserve and maintain those resources. And the beneficiaries that are named are not only the present generation, but future generations. And that's in Article 1 of the Pennsylvania Constitution, which is the state's Bill of Rights. And as you all know or will know, the rights that are in the Bill of Rights are basically rights that we have as against the government, right? The government can't take away your right to free speech. The government can't take away your right to freedom from unreasonable searches and seizures and so forth. And in almost no time, the Pennsylvania courts buried the amendment. And they did it in two distinct ways. They said, well, in the first case, there are a couple of early cases that are worth describing in a tiny bit of detail. One involved a challenge to the construction of an observation tower just outside the Gettysburg Battlefield National Park. It's on private land, no government approval is required. And it led in the claim about that the observation tower would interfere with the experience of people who are in the battlefield, trying to get a sense of what the battle was like, sort of wasn't as compelling as you might think, partly because a lot of people aren't trying to get inside the heads of the soldiers in 1863, and partly because the tower itself provided a pretty cool view of the battlefield. Everybody I know who's been in the tower, I'm not one of them, but before it was demolished, thought it was a great view of the battle. And so, and the Attorney General was. But the larger point is that that initial case got people thinking that what the amendment was all about was the assertion of governmental power. Okay? And that led to a series of cases that say the amendment only applies when the legislature says so, that it's not self-executing. No other law like that for Article 1. The second thing that happened was, in another case with weak facts, the Commonwealth Court, the Intermediate Appellate Court in Pennsylvania, said, well, instead of this is looking like the amendment is anti-development, and so to make it more friendly to development, what we're going to do is substitute for the text of the amendment a three-part balancing test. So what you had until this past December, with the state of the law was, about 85% of the law was, the amendment only applies when the legislature says so, and when the legislature says so, we apply a three-part balancing test instead of the text of the amendment. That's where we were. And then on December 19th, Pennsylvania Supreme Court changed all that. They said, and the case involved a challenge to the constitutionality of several provisions of Pennsylvania's Marcellus Shale legislation. And one provision in particular is worth sort of focusing on. It said that local governments have to allow shale gas operations in local municipalities, even in districts, in zoning districts that are zoned residential. Okay, even in districts that are zoned residential. For real. Okay, I couldn't make that up. And the Pennsylvania Supreme Court issued an opinion by vote of 4-2 saying that this and several other provisions of the statute were unconstitutional. 3 justices said, well, recognize first of all, I mean, in the 3 justices three justices based their decision on Article 1, Section 27. And they reframed the conversation in 3 kinds of ways. One, it was the first time that the Environmental Rights Amendment had ever been used to hold a provision of Pennsylvania statute unconstitutional. As near as I can tell, it may be the first time public trust doctrine has ever been used, even by a plurality, to hold a statute unconstitutional. The second thing they did is they said, oh, by the way, this is constitutional law, right? And sort of shocking thought. And they said, you know, what you need to really understand is that this is an Article 1, and Article 1 rights are rights as against the government. And what the legislature did here is it took away from local governments their ability to ensure the protection of constitutional rights. Because at the local level, people were saying my environmental rights are being interfered with. The sense I have that I can sell my property for some, what I paid for it, it's diminished greatly. There's going to be shale gas operations down, the next block over or whatever. And so they recognize that it's in Article 1, which is something that has been kind of lost in decades of litigation in Pennsylvania. And the third thing they did is they used and applied the text of the amendment. The text that the legislature took so much care to write. They actually said, we shouldn't apply the pain test to this three-part balancing test I was talking about. We should actually apply the text. Now, and there's been huge shockwaves in Pennsylvania about this. The fourth justice came down and provided the majority by making an argument based on substantive due process. But in just a couple of minutes, what I wanted to do is to just sort of set the table, if you will, for this and give you a sense of how much has changed, but how much has been left unsettled because of the simple plurality of it. And I'll just stop there.
So I've been, as was said, I've been working in the field of LGBT rights generally for the past, a decade or so, and in the last couple of years specifically focusing even more so on transgender rights. So I kind of want to talk about, focus on my work and the work of the movement in marriage, same-sex marriage rights, and also privacy protections for transgender students, or privacy issues related to transgender students. The LGBT movement generally has been pursuing a strategy for many years, preceding the past year or so. It was sort of, the situation has really changed since the Supreme Court's decision last summer in Windsor striking down the Defense of Marriage Act. But prior to the last year or two, since the early 90s, the movement has been pursuing a strategy to strike down laws that limit marriage to a man and woman, barring same-sex couples from marriage. A strategy of focusing with, almost entirely exclusively on state constitutional arguments. And that is largely because of a fear of going to the U.S. Supreme Court prematurely. That we didn't want to get a negative ruling that would set everybody back, in theory, 20, 30, 50 years, because the Supreme Court doesn't like to, like any court, doesn't like to reverse itself too quickly. And we were all looking at the experience of, that Loving versus Virginia, the Supreme Court didn't want to get involved and strike down laws against miscegenation, marriage between people of different races until the late 1960s, when the majority of states already prohibited this. And we were looking at a situation where across the country, starting in the 90s, no state permitted same-sex couples to marry, and then even through the late 2000s, it was still under 5 or so. So this was not a situation where anyone felt really confident going to the Supreme Court. And we had seen, for instance, sodomy law challenge being rejected by the Supreme Court in the mid-80s. And that, everyone felt like set the movement back and was really hard to overcome and sort of reify discrimination against LGBT people. So folks started bringing state-by-state actions, arguing solely under state constitutional provisions, largely focusing on equal protection, of state equivalent of equal protection arguments. And we saw that win in a number of states, starting in Hawaii, although that was reversed by a state constitutional amendment. That, of course, is the downside of bringing these cases under state constitutions. Vermont almost won and got civil unions instead. Connecticut, and then California was a really great, huge win for the movement in 2008. The state Supreme Court striking down the state's statutory ban on marriage between same-sex couples, which was promptly within a few months reversed at the ballot box with Proposition 8, which was a state constitutional amendment that put back in place, in a harder to undo way, reversing the state Supreme Court's ruling, and saying that it was unconstitutional for the state to recognize marriage between same-sex couples. Now, because of all this background and anxiety about going to the U.S. Supreme Court, we advocates, I was at the National Center for Lesbian Rights at the time, were scrambling to figure out, okay, how can we possibly undo this terrible, terrible ballot initiative, but avoid the risks of going to the U.S. Supreme Court. And so we hit upon this ambitious, novel idea of making state constitutional arguments against Proposition 8. And we filed a writ petition with the California Supreme Court, I believe the day after Proposition 8 was enacted. I remember we spent the election night at the office and went home at like 5 a.m. and everybody else around the country was celebrating the election of President Obama, and the LGBT movement was very conflicted because we were also facing the passage of Proposition 8 that same night. But we were up all night finalizing our writ petition and took it to the state Supreme Court in the morning, are making the argument that Proposition 8 was such an egregious violation of equal protection principles by using this bare majority system, the state initiative system, to take away the rights of a minority that had been established as part of the state constitution. And so we said that this was such an egregious violation that it actually constituted a revision of the state's constitution and not an amendment. And these are two different categories that are established in the Constitution itself and over time in case law that say that, and for a revision you're supposed to go through much more difficult process to get it enacted. So the legislature has to be involved, there has to be a 3/4 vote rather than a simple majority, straight to the ballot. We were fabulously unsuccessful. We lost at the state Supreme Court on a 6-1 vote, although we did get one, so that was something. But it was an interesting, it's interesting that this can even be attempted, at the state court level. And then, right as soon as we got that ruling from the state Supreme Court, then Ted Olson and David Boies filed their federal court challenge to Proposition 8, which, largely set the ball in motion that led to the current state where, as I said, the Supreme Court has struck down the Defense of Marriage Act, and now in just the last year we've seen federal courts in half the states striking down state bans on same-sex marriage under federal constitutional law. I just wanted to touch really briefly on the privacy issues that I also work on relating to the state constitution. California has a unique privacy provision in Article 1 of the California Constitution. It says that every person has an inalienable right to life, liberty, etc., and privacy. And that was added in the early 1970s also. And the California courts have found that this right is broader and deeper than the parallel right to privacy under the federal constitution. And this has been, has been used both as a sword against transgender people and has been a helpful shield, because we have used it to our advantage in arguing that schools, for instance, cannot reveal a transgender student's transgender status to other people without that student or their family's consent. That the right to that sort of private, confidential information is entitled to the utmost protection. And so, this extra strong privacy right has been very helpful in that regard. But it has also been relied on by folks on the other side who have said that this privacy right in California means that if a non-transgender student feels uncomfortable sharing a restroom or a locker room with a transgender classmate, that this privacy right should mean that the transgender student has to be, segregated into, required to use either the facilities that accord with their sex at birth or a separate gender-neutral facility, but that it's such a deprivation of non-transgender classmates' privacy rights that it can't stand. And fortunately, we were able to prevail on the one legal challenge that has been brought using that argument in California a few years back. But we absolutely expect our opponents to keep raising this. So privacy for transgender people is, and especially for kids, is absolutely a double-edged sword. I would argue that privacy is an interest that transgender people and transgender kids especially hold very, very dear. They tend to be incredibly private and even, shy about their bodies and revealing their transgender status. I mean, this is a very intimate piece of information for other people to have. And so it is ironic in a way that other people are using this concept of privacy to deny them of the simple right to participate in school activities along with everyone else. So I'll stop there.
So it's great to be here this morning. I was actually on the steering committee for this conference about 9 years ago actually now, so it's nice to see that Kobe's still doing the coffee cake for breakfast. I do a lot of work on education, and it's actually, my background is a lot easier because the state constitution is pretty much the only game in town for people who want to litigate around educational rights for children. The basic sort of way that has played out is that the state constitutions of about half the states at this point have recognized the fundamental right to education. It's been framed one of two ways: either as a right to equal educational opportunity, or as a fundamental right to a sound basic education. One is sort of an equity comparison frame, the other is more of an adequacy framework. Bill Koski, who's a professor here, has written 2 wonderful articles on this, so if you're interested, I encourage you to read them. But basically, that's what's left, because in 1973, in the Rodriguez case, the U.S. Supreme Court said no fundamental right to education under the U.S. Constitution. And then in 1976, Washington v. Davis, the intent doctrine, in order to use the Federal Equal Protection Clause to sort of try to do any kind of work in the schools based on racial disparities, had to actually demonstrate an intent to discriminate against minority students in order to bring a valid federal constitutional claim, which generally doesn't happen. It's basically impossible to do that. So what's left are the state constitutions, and every single state constitution in the country actually has either an article or a provision, often in the Article 1, where fundamental rights live, about the state public education system. I think within the history of the United States, K-12 education as well as higher ed have pretty much been a state-level practice. The one area is sort of the federal land grant for higher ed, but beyond that, it's pretty much a state-level activity. And so, pretty much what we do, if we're going to be litigating around education, is rely on state constitutions, and there's usually a recognized cause of action against either the school districts that are responsible for day-to-day operation, or the state itself, or the state educational entities that are responsible for overseeing and superintending usually the school district-based system of public education. And so I've spent a lot of my legal career doing this type of litigation. I can actually talk in 2 different states, sort of what that's looked like. And in North Carolina, which is where I first started practicing, there was a case in 1997. The state Supreme Court recognized a fundamental right to education, adopted an adequacy framework, so it was a right to a sound basic education. But that case was a school finance case. It was basically saying how much money does the state have to give to school districts. The students weren't even, by the time it had been decided, all the student plaintiffs had graduated, So all that was left in the case was the districts fighting against the state about how much money they would get. And so what I did in North Carolina was basically try to implement this fundamental right to education to figure out how to make it an individually enforceable right for children. What it ended up, you can do lots of interesting things with a fundamental right, and what our office ended up doing is focusing on actually school discipline. We filed a series of cases challenging expulsions, arguing that the procedures that were in place to expel children did not recognize the fundamental nature of the right at stake. And the case that I worked on after I left ultimately went to the state Supreme Court and found that there's sort of basically an intermediate scrutiny that has to be applied before a student can be kicked out of school. So that's sort of like one example of where once the fundamental right is recognized, sort of how you can use it whenever students are being deprived of access. So that's one example. And then since I've been in California, at the ACLU of Southern California, we've done a lot of litigation under the state constitutional right to an equal educational opportunity. And what we tend to do is focus on the state as the sort of ultimate guarantor of the fundamental right to education. Even though school districts run the day-to-day operations, there are 1,034 school districts in the state of California. So if you have to go around suing every single school district when kids are getting, not getting what they should be getting, we're not going to make much progress. So we tend to focus on theories that identify systematic breakdowns in sort of basic equality of opportunity and try to establish systemic sort of monitoring and intervention programs that build upon a 1990, usually most directly a 1992 California State Supreme Court case that held when a school district was going to close early because it ran out of money, the state had to step in and make sure that the kids got the full school year so that their education didn't end at the letter P. So we really rely on the idea that the state has to step in regardless of responsibility. If the district's at fault, it doesn't matter. And so we use that principle to try to sort of tackle these systemic challenges. And what that's looked like is the Williams litigation, which actually was filed before I joined the ACLU, was focused on basics of education, and making sure every kid has a textbook, has a certified credentialed teacher, and has a safe and clean school facility to learn in. That's sort of one case. And then we've sort of built over time and done sort of a series of cases. And then most recently, we filed a lawsuit in May against the state that focused on sort of the fact that students, particularly at low income, who attend schools in low income communities, almost exclusively students of color, attend schools where they get a lot less instruction time because the school has to cope with such extreme challenges that basically kids get weeks and weeks less of instruction through no fault of their own, and we have argued that that's sort of a deprivation of fundamental right, and the state has an obligation to step in. The one point we were talking a little before the panel started is that, this is not a hard issue. The state Supreme Court since 1924 has said the state is ultimately responsible, yet we always have to remind people of that. That the state actually is responsible here. In every single case that we file, the state's argument is not our job. And they always file motions to dismiss on that basis and always lose. In the cases that we filed at least, yet we still, every single time, they'd say, why are you suing the state question? The districts are the ones who are responsible, yet we still have. So even if it's clearly established law, it's amazing how difficult it can be to remind people in litigation, but I think even more importantly, the public and in policy making. Reminding legislators and this governor in particular that no, actually the state has a responsibility here. Is an ongoing challenge. Even, we're looking at 12 state Supreme Court decisions since 1924 that have reaffirmed this principle.
Thanks very much. Also, as you can see, there's sort of a range of different experiences that people have had here with state constitutions and how they implicate work in very different fields. Trying to sort of draw one theme out of this area is, some of this stuff is stuff that was established a while ago, either in the 1970s for the environmental rights or even longer ago for the education rights. And picking up on Ilona's idea of the double-edged sword, obviously one feature of state constitutions is, although we have not had a federal constitutional amendment in quite some time, state constitutions are being amended all the time, either to potentially withdraw the marriage equality rights or in educational sphere. There's obviously been some assaults on affirmative action over the last few years. So in the current environment that we're in right now, do you feel like which edge of the sword do you feel is sharper? And are progressive advocates able to be on the offensive in how they use their state's constitutions, or is it really more trying to preserve gains from the past?
I'll say for the LGBT movement, we have had a lot of success relying on long-established constitutional concepts like equal protection, due process. I'm not aware of any recently enacted constitutional provisions, state constitutional provisions, with the possible exception of, the privacy and other things that may have been put in place going back to the 70s, but there's nothing like on the table now in any state that I'm aware of that would possibly be helpful. I mean, when you're fighting for an issue that is, on the cutting edge, like we don't have a majority support of the population in any state. I mean, maybe barely now, just starting to be for, say, same-sex marriage rights, but, if we're talking about transgender rights, you're probably looking at, in somewhere in the 20% range. So yeah, we really like the kind of judicial intervention, mode of attack, litigating based on creative arguments and the sort of separation of powers. The general public voting on things tends not to go so well.
Well, how about in the educational sphere? It sounds like you've been having some success in court, but...
Well, and not to totally take us veer into the right to a broader question, but I think that one downside or challenge, and I think this is looking at, we can win all the cases we want, are we actually changing the reality for people? And I do think that there's a real possibility, and something that I think that we, our team, we struggle with a lot to sort of ask these questions is, sometimes the state constitution can be the new and shiny thing that we want to try to use, and the question is, does it actually make sense to do that? The amount of resources that go into litigating some of these cases are tremendous. We just won a case, we have about $3 million in attorney's fees that we're going to be filing a petition for next month. That's really nice if we get those fees, but the question is, how much resources went in from the law firms and other nonprofits we were working with to get this legal victory compared to something else. So I think that there's a real, one question that I think is an important one to grapple with, and looking at, should we push a new constitutional amendment? I was involved in a conversation earlier this year where I was just shaking my head, where I was like, why are there 20 people in a room spending half a day talking about this? This cannot be a good use of resources, because this is a terrible idea as far as actually making a difference for people in their day-to-day lives. But it was specifically, should we push a constitutional amendment to do something in the California Constitution? And I think that there is a risk of trying to glom onto, especially how disheartening some of the federal litigation is sort of like, hey, maybe the state constitution is the answer. And I guess the question that I would ask is it the legal theory or the clause that is the problem with the federal constitution that would make the state constitution a better vehicle, or is it the overall strategy? I don't know that there's always the right, I'm not saying it's never a good idea. I litigate under the state constitution all the time. So, but I think that we don't necessarily ask that question often.
Yeah, on the environmental side, the story is a little bit different. The simple answer to the question about sort of the political piece of this is the environmental rights amendment that I read to you would absolutely not likely be even approved by the legislature in the current climate that we have. And so, to some degree, it's an artifact of its time. And it was adopted in 1971 at the dawn of the modern environmental era. And some of you who are still in your first year of taking environmental law. What happened was we went from maybe not quite 0 to 60, but maybe 15 to 60. All right, in about 10 or 15 years, beginning at about 1970. States had pretty good laws, California better than others, but a whole series of federal laws passed that really substantially amped up the quality of environmental protection that is accomplished all around the country. And so what happened was the need for the amendment became, as the courts buried it, the need for the amendment became less obvious because there were statutes, there were regulations, the Department of Environmental Resources, now the Department of Environmental Protection, had all the staff, all of this. But what happened with the shale gas legislation, so you had this huge ramp up in environmental law that occurred between about 1970 and about 1990, both at the federal level, and then it had all kinds of impacts at the state level. And then what you saw with the shale gas legislation, and beginning to see this in other places as well, is some scaling back of the environmental laws. This is what we had, now we're not going to do that anymore. And to some degree, that's what drew the Supreme Court in. All right, and so part of what might be happening with the environmental amendment, we'll see, is the environmental amendment could be something of a bulwark against retrenchment, if you will. One other thought that I've been sort of talking to people about the environmental rights amendment, because I absolutely agree with David, if it doesn't do any good on the ground, what really function does it serve? I mean, what happened in the Robinson Township case is the plaintiffs, the petitioners, thought, they saw Act 13 and they thought, this is really horrible. What legal rule can we use to challenge this? And the litigation that they filed was like a 12 count, it's like everything, Santa's bag of every last thing you could think of to challenge the state statute with. And this is really, and this is like one of the things that's stuck, right? And I think part of the reason it's stuck is it resonated with the justices. But the challenge on the environmental side, is, well, what do you do with an environmental rights amendment? People even have trouble conceptualizing this, right? Okay, I get free speech, right? I get right to bear arms. We all get, whether we like them all or not, the basic rights. And right to clean environment, what is that exactly? I was talking to one of the key state government environmental people. I had lunch with him the other day, and he said, I said, Doug, it's in Article 1. That makes a big difference because you're talking about balancing environment versus the economy and all of that, which you might do in other contexts. I said, no, you don't get it, okay? What's happening here is decision makers get to balance. They get to look at the relationship between the environment and the economy and the shale gas legislation. But if they strike that balance in a way that hurts people's personal, individual, constitutional rights, that's a problem. And balancing doesn't get you off the hook for this. And so what happens is you've got environmental law, which is heavily anchored in administrative law, and people are having a hard time getting their heads around how Article 1 right actually works. All right, and so you're going to talk about all these interesting ideas while you're in law school and all this really cool stuff, but if people don't get it, if judges don't get it, if lawyers don't get it, that's a problem. But the one last thing I'll say about the Environmental Rights Amendment is the pitch that I've been making is it's a gap filler. It's a gap filler because, I think I'm right most of the time, but there's a lot of people, particularly my friends who work for the corporate bar or work for the shale gas bar, are really nervous that something very radical got let loose when this decision got made. Because as a practical matter, this is really, honest to God, true. It's as if Article 1, Section 27 suddenly appeared in the Pennsylvania Constitution on December 19th. That's how big a deal this is. That's how thoroughly it was buried. I can't tell you the number of lawyers that I've talked to who are responsible for advising clients. And you know the drill, right? What are your risks? All of that sort of thing. What is the likelihood? What is your exposure? This came from like way out of the blue. They had no idea this was coming down. And a lot of them feel pretty defensive about having missed it. But the argument that I've been making is it's a gap filler. And so, for example, if the environmental laws work perfectly, Okay, they're the best environmental laws you can have. The leasing on state lands, forest and parkland for shale gas right now is a controversial question. And there's a case that was just argued 2 weeks ago in Commonwealth Court on this. One of the questions is cumulative impacts. You have the best regulations, the best rules in the world, but they're not protecting against something. Okay? And my argument is, okay, if you've got something like that, and that's a serious infringement of rights, then that's maybe one place where the environmental amendment would be appropriate.
Very interesting. So I want to put one more topic on the table and then make sure we have time to get some questions from the audience as well. But so obviously one feature of state constitutions is that while there is one federal constitution, there are 50 state constitutions, and I think we've heard a little bit, how that played out in the marriage equality realm. But I'm just, as folks who work sort of primarily in California or in Pennsylvania, I'd be curious, in the issue areas you work with, is there a lot of communication across different states where different innovations are going on under the Constitution? Is this sort of an opportunity, are state constitutions an opportunity for, progressive advocates to try something out in particularly fertile ground and then try to have it spread? And I'd actually be particularly curious in the environmental context. Just before preparing for this panel, I didn't even know that some states had environmental protections in their Bill of Rights, and I'm curious how much that caught on and how that spread. So,
all right, well, I'll start and I'll try to be brief. A lot of states have something about the environment in their constitutions. Only 2 others, I think. Rhode Island and Montana have it in their Bill of Rights. A couple of others have a right that is located elsewhere in the Constitution. And judicial enforcement varies a lot. Some of the more progressive states are Hawaii, Montana, California, and in a lot of the other states. There's actually a pretty interesting recent Alaska opinion. And that's part of the thing about this is it's really hard to generalize about this. One of the interesting things that's going on right now on climate changes, there's a group called Our Children's Trust that is making arguments in as many states as they can think of, using 17, 18, 19, 20-year-olds as plaintiffs or petitioners, that the state has an obligation to reduce greenhouse gas emissions in order to protect an atmosphere of public trust in current and future generations. I'm not sure how far that's going to go. There's even a cert petition making a claim that there's a trust obligation under federal law before the U.S. Supreme Court right now. I'm not sure how far that's going to go. And that's probably, I think, as much as I can say.
One thing that came to mind with that question is sort of in thinking about cutting edge litigation for trans rights in particular. One area is that we and other national groups, litigation groups have been looking at is striking down or reducing onerous state barriers to getting ID documents that reflect a person's gender identity. And some of these barriers include surgery requirements that actually don't match up with how most transgender people live their lives or healthcare that they're even able to access. And certainly there's a lot of due process and privacy arguments that can be made and are just starting to be made. And it's definitely one of these surgery requirements, for instance, are in place in at least half the states for driver's license, just to get your driver's license, gender marker change, in 95% of the states to get your birth certificate changed. And in terms of seeking out places to bring test cases to start establishing this argument that it is a violation of some kind of fundamental right to have this be forced to undergo medical treatment that is actually sterilization. One of the considerations is definitely what does the state constitution provide. There are a lot of factors that go into choosing test cases, but that is certainly one of them if we're a little bit anxious about the scope of protection that's going to be available under the U.S. Constitution and or what a federal court or U.S. Supreme Court would do with such a case.
And I think that answer just highlights the importance of whether there's a movement behind the right or the issue that's being established. I think that there is no movement for education rights as such in the sense of a nationally unified focus. So I think that's in large part because education is such a state-by-state matter from a policy-making level. But the way that it has played out, however, is people borrowing successful arguments. So the educational litigation is broken up into 3 waves. Wave 1 is the federal that was foreclosed by Rodriguez. Wave 2 is the sort of more equal protection version that was started here in California in the Serrano litigation. And Wave 3 is what's sort of been called the Advocacy movement. And that was actually a Kentucky case, the Rose Counsel case in 1976, that basically advocates just borrowed. And the Leander case that I was talking about in North Carolina was basically Rose Counsel all over again. And there were at least 14 states that sort of the litigation strategy just totally mirrored the Rose Counsel case, the way that was built and litigated. So I think people can borrow from successful litigation strategies, but if there's not a movement, the idea of picking the best state to try it out and just you need to have some more of a unified movement for that, I think.
Well, now would probably be a good time to open it up to questions from the audience, if anyone has anything they'd like to ask any of the panelists or all of the panelists. Deepa?
Kind of piggybacking off what you guys were just talking about, how do you get general public awareness around state constitutional issues or state issues as opposed to federal ones? I feel like I hear a lot about national movements, but I don't know that much, for example, of the California education movement, and I've grown up in the system. So I'm just wondering how you guys deal with spreading public awareness about these issues.
You're assuming there is a California education movement. But I mean, one answer I think just kind of an interesting, I'm not sure it's actually answering your question, but it's a related point, is just how state constitutional rights can influence policymaking and public advocacy more generally. And I think that that's been a real challenge. As I said, the state itself forgets that it's in the Constitution, right? And California, Governor Brown is very much into this subsidiarity concept that he created about we need to push down control of local. That sounds an awful lot to me like the 1960s in a way that's a little scary. But one thing that we can push back in, the realignment, which is pushing down control of the criminal justice system, prisons, and jails down to the county level, that's basically a strategy to relieve debt at the state level is why Governor Brown is so strongly behind it. But we can actually push back for his effort to push down local control in the education system, which is reflected in sort of recent legislation, the local control funding formula, that all the state policymakers be like, oh, we're local control. We can actually point to the state constitution and the state Supreme Court cases and saying, yes, that's good in concept, but there actually is a non-delegable state role here. The same argument isn't available for the realignment debate. The state is fully capable of basically like, counties go fend for yourself on how they take care of low-level criminal offenses. So I think that we've very actively and proactively and more consciously now, any sort of public advocacy, when every time I meet with a legislator, I start with, let me tell you about the history of the state constitution. Because I think that there is a lot of awareness building that needs to go into these provisions, especially because they sometimes get lost and forgotten.
Just the one little piece on education that I would share, and I have a little different perspective. I mean, I worked in state government for quite a while, but teaching now is, when you say education, it depends enormously on your audience. And right now there's an awful lot of people in Pennsylvania environmental bar that are learning about Article 1, Section 27 for the first time. And I've done a ton of speaking around the state about it in the last 8-9 months. But the other bit of education, and I think it's worth thinking about from the standpoint of possible roles for you out in the real world, is some of this started with me When I worked at the Department of Environmental Resources, there were posters of Article 1, Section 27 everywhere, and I kept thinking, gee, wouldn't it be nice if this were law? And so I went into teaching, I thought, well, what does this environmental amendment mean? And I went back and I dug around in the legislative history, and I found out all kinds of things. And as I started writing this, and it got to be kind of long, it was actually a 2-part article, I spent a lot of time explaining how the court could apply the amendment if it decided to give it life. Those are 2 articles that were published in 1999. And so I'm reading this opinion this past December, and I'm seeing those articles cited over and over and over again, and a very large hunk of the plurality opinion actually keys off on those articles that I wrote. And now I find myself in a position, 2 weeks ago, having filed an amicus brief in the Commonwealth Court because the state screwed it all up, is explaining what the law actually means. All right? And so from an educational point of view, don't lose the thread that you can educate clients, the public, courts, other lawyers about what you know. And don't lose the thread of the teaching and educational role that you can play on whatever issue you work on.
Any other questions? Great.
So I'm curious about the sort of sword shield issue, but thinking a little more concretely, sort of curious about your decision process when thinking about when to pursue a state or constitutional remedy for some of these issues. Thinking particularly in the education context, where we have this mandate to have textbooks in classrooms, right? I think I've worked in education for a while, I've been in a lot of classrooms where you have huge stacks of textbooks that haven't been touched in years, right? And yet other funding issues where they're not able to get the sort of supplies they want now, but textbooks are required, so you have lots of textbooks. So I'm curious if there's a thought process in thinking sort of, is the state or the constitutional remedy the right one here because it sort of cements you into a certain path, or are legislative efforts or local efforts? So how do you balance, because they're more flexible and can be revised as the situation changes? And I can imagine there's sort of environmental issues that are the same as we discover more about environmental impacts of certain technologies. We might want to be more flexible as opposed to sort of stuck in a constitutional sort of mode.
So water always finds the cracks. Is sort of the starting point that I've come to in answering that question in some ways. I think one of my mentors says every system he's ever seen is the same system, and that's true. I think bureaucracy is bureaucracy, and it's very often the same issues regardless of what the actual issue or system is. But I think that sort of that can become kind of trite, actually. It's sort of like, oh, but if you think about it only as litigation, that doesn't really tell you much. On the other hand, I think the same analysis applies to legislation, to organizing, to public advocacy campaigns. The question is being very clear about which is the best strategy to actually change what's happening and also mitigate unintended consequences, and be very conscious of where those pressure points are going to be so that the water is going to slip into the other crack. Because we basically find ourselves on whack-a-mole a lot. And so I don't know that there's a clear answer to that. I think the answer is I'm not sure we think it through very well. Just honestly, I think that as a movement, just this public interest movement, we're very siloed into issue areas, but also into types of advocacy in a way that can be very challenging. We do what we do. If I hire a lawyer as the sort of next staff person I hire, we're going to sue more. If I hire an organizer as the next staff person we organize, we're going to do more community organizing. But those choices really impact our decision-making process. And I think as organizations, we often are not very conscious of that, or we're very reflexive. I think that's a much broader issue, but I don't think we think it through very well.
I'll just chime in quickly in response to the previous question also, that I think what makes a difference ultimately for any of our issues is public opinion. If we have public opinion on our side, reality on the ground for our clients and communities will improve. And you'll have people naturally wanting to do the right thing rather than having to be forced to by court or law that may or may not be enforced. And one way to move public opinion, as we've seen in the last year or so with marriage, is getting wins in the court. I don't know of any other way, frankly, to communicate about what the Equal Protection Clause or any other state, especially state constitutional provision means, or why people should care about it, other than when we have a court stepping in and saying this is such a fundamental right or violation of a fundamental right that we're going to step in, and that tends to get people's attention and can be a useful public education tool. But I think that's really what it all comes down to is public education and using these things are just really like incremental, tiny changes, whether it's a new law or a constitutional win or anything, those are just like a tiny bit of progress in the bigger struggle.
Just two quick things to add to all of this. I mean, one of the reasons it's important to have a panel on state constitutional law at a conference like this is that state constitutional law is really in a different place than it was, say, in 1970 or even 1980. Some decades ago, Justice Brennan on the U.S. Supreme Court began to bring attention to state constitutional law, and what used to mean, I'll give you a sense of how it used to go. If there was a First Amendment right in a state's constitution, the state Supreme Court would say in a particular case, well, what did the U.S. Supreme Court do on this issue? Oh, okay, that's a little bit, all right. Where the state constitutions were sort of like the little league of constitutional law. I mean, I don't think that's an overstatement. And except maybe on issues of internal governance, right? The legislature and separation of powers maybe, but even on some of those issues, they would sort of say, well, what did the federal U.S. Supreme Court say? It's really different now. Even on a lot of points where the state right is stated in essentially the same right as the federal right is stated, you're seeing independent analysis more and more by a lot of state courts. And so state constitutional law is a different place. In whatever state you finally wind up in, be aware of what's going on in the state constitution. Be aware of the tools that the state constitution provides. The other quick thing that I'll say is, because the situation in Pennsylvania is so fluid, a lot of us are really sensitive about the facts of particular cases. And I do think that what happens in a lot of these cases is the facts really drive things. This stuff is really off kilter. And this is to some degree what happened in this Robinson Township case. If things are really off kilter, the state court will find a rule, okay, to knock something down. And so as you go out and do the things that you're doing, I think what I've been counseling people, what I've done is in Pennsylvania on what do we do now, the same thing that I would counsel you on is look for cases with really good facts. Look for cases that are going to encourage the court to decide the case in your particular way. Don't spend a lot of time and energy on stuff where what you're going to get really isn't all that significant. I mean, a couple of the early cases in Article 1, Section 27, as indicated at the beginning, are just horrible cases. And they convince the courts that this is a bad thing. And if different early cases that involve different facts, I think Pennsylvania law would have evolved in a different way.
And compelling facts are going to convince the public, who is, again, who you ultimately need to get on your side.
Yeah, fair enough.
So I think there's both the question of choosing among strategies and making the strategies work together so that litigation is communicated. I want to make sure people have a little bit of time between this and the workshops, but we probably have time for one more quick question if anyone. Yeah.
So I think strategies for changing state law, we talked about, organizing, educating the public, crafting the perfect litigation strategy, finding the right plaintiffs. It seems like one big missing piece is changing state Supreme Court personnel. This is an area where it's totally different, across states, but all pretty different from the U.S. Supreme Court. And just judges have to get elected in many states or answer to voters through retention elections. I mean, what do you all think about this? Is this, legitimate strategies for progressive causes to pursue? Everyone's sort of very worried about digging into democracy here. We want independent courts so we can, have judges who are going to come in and serve causes that the public doesn't like. Thoughts on the use of that strategy?
The first thing that comes to my mind is how that theory has been used against progressive causes with recall elections of judges, both here in California after the death penalty rulings, and in, for instance, Iowa after that state Supreme Court struck down the ban on marriage for same-sex couples. So, we can do it in a subtle way, sure, but our opponents are making great use of that.
And I would say our opponents are making great use of that strategy, and we sometimes stand on principle and lose. I think that that's something that it's distasteful. It makes a lot of people feel icky. I think it's something that they're doing. And I think that there are a lot of strategies and tactics that are being used that our side stays away from. That I think a lot of times do with money, frankly, also, that they have a lot more money than we do, so they get to try lots more different strategies than we do. But I do think that that's a very interesting question. And the answer of why we don't do it is because it's distasteful.
Chief Justice Castile, who wrote the plurality opinion, is retiring at the end of the year, mandatory retirement. So now we had 3 votes, now we're down to 2. Of the 2 that are left, one of them is causing a scandal. I won't get into the detail. It's way too interesting. It would distract you all. So part of what I've been trying to do is convince people in every way I can that what was being employed ought to be employed by the other justices and the other judges, using traditional rules of constitutional interpretation. But and that may work for some of the remaining justices and judges. We'll see. Big act of judicial usurpation of the decision maker, of judicial activism with these early cases in the 70s, not the one that I've been arguing, not the recent one. But yeah, absolutely. I mean, there's a lot of cynicism, frankly, in Pennsylvania about whether this decision is just a blip.
Well,